welcome back to In Your Money. We're discussing estate planning this evening. My guests, Harry Joffe and Terry Berkowitz. And if you'd like to email us, my email will appear on the screen. Just one comment. I quickly want to get through a few more questions, and then I want to get to emails. So my question to you is, Terry, very simply, why is such an important document that an executor or family member should have access to in order to prevent any delays?
As I said, all original wills and codicils, and as Harry mentioned previously, the latest will and latest codicils, together with original title deeds for your immovable properties, vehicle paper registrations, the originals of that. Another problem I'm seeing is building plans for your property. When you want to sell your property, there's big problems at the council, so you need to make sure you have those building plans. It can frustrate a sale. The SARS contact details that the OTPs will be sent to. Email addresses. I once had a case now where someone hacked the deceased email and was requesting payments. All we needed was the password in order to boot them out, and no one knew the password to the email. So emails, PACs, PINs.
Passwords and PACs
and PINs to the phone, etc., especially with the changing technology. Everything.
Yeah, digital. Digital is so important. You know, crypto, the passwords to your crypto and the keys to the crypto.
You know, just to let you know, we've produced, because I've often talked about the life file, we've produced a document, an 8-page document, which clearly states the documents. And if anyone wants to, you can please go onto my website and we'll gladly have a look at it, and you can gladly...
But Bryan, crypto is an issue because clients don't want to put their crypto code on paper. So it's all very well having a life file, but no one wants to put it in writing because it's such a confidential thing.
Well, you have to put it in your life file for your family.
Yeah, but you put down, I've got crypto, but that password they want in a very secure vault or some other secure system. Crypto codes are a big issue with us and clients, I can tell you.
And then, Harry, this is a question we've discussed, you know, how important is it who you appoint as executor?
Yeah, Bryan, I mean, it's an ongoing issue. So it's not a right or a wrong answer. I mean, you can appoint a law firm or a trust company or a bank. As long as, number one, as Terry said, you discussed your executor's fees with them. You've got to be clear that they're not going to charge more than you've expected or budgeted for.
Well, you wouldn't expect anything because you're not alive.
So well, you and your family. Sure, your heirs and
family.
beneficiaries. And Bryan, very important, you've got to be sure they can do the job. You know, a lot of law firms will do it kind of as an aside, or an accounting firm will do it as an aside. But you want someone who specializes in estate planning and being an executor. You know, Terry will tell you things like, the master will lose a will, potentially. Have you got a second original will on file? Can you create these dummy files? Do you have someone who goes to the master every week to check what they're doing? You can't have someone who's doing it part-time. You know, there must be a specialist in winding up estates. To me, that's the most important.
Terry, if you have a will, which you're going to send to the master's office, do you have the right to copy that will, certify that it's a copy in case the will gets lost?
No certified copies are accepted by the master, only originals. But there was recent case law where they actually did accept a digital copy that was on email. There was no original and there was a digital copy, and that was accepted. So it seems like case law is changing, but it has to be an original will. And if it's you know, you have to, as Harry said, the importance is that an expert lodges that will and that they know where it was lodged. What happens is attorneys take on estates, and because their court matters take precedence and because of the deadlines, estates don't really have such hectic deadlines. Their estate files go to the bottom of the pile and they don't get looked at again. You know, every 6 months it comes up again. So it's really important that you know who you've handed it in at the master, that you get a stamp who received that original will, and that someone is always going back to the master and checking up and finalizing that estate before you allow that document to get lost.
So what happens if you've sent a will to the master's office, you've had it signed for, and the master suddenly can't find it? Then what happens?
I think if you've had proof that you submitted it, as long as you get that stamp that it was submitted, I believe that they would, you know, you would be able to write to them and tell them, I did submit the will on this date, but you must get that receipt stamp that they did accept the original will.
Are doing 2 original wills for clients, and they keep the one in their file and then they submit, and then if the master
but that's 2 originals signed.
Yes.
Not the photocopy. 2 originals signed at the same time, same day, same witness. So it's 2 original wills.
I advise all my clients to sign 2 original wettings.
And Harry, where would you say a will should be stored?
Okay, so Bryan, if there's one thing our viewers take from today is please store your will somewhere safe and somewhere with a professional. So, you know, if Terry's drafting your will, store it with her law firm. If we're drafting it, store it with us. Because, first of all, when the client dies, no one knows where the will is, and we have so many of these cases. You know, the one case we had, the client had stored their will in their tool shed in a toolbox, and it took the family 3 months to find the will. So send it back to the expert who drafted your will for storage, number one. And number two, it should be free. I mean, all the experts, all the law firms store it for free for you. But I think most importantly, when the will comes back to us to store, we can check, have you signed it properly? You know, are the signatures at the bottom? Are the witnesses not beneficiaries in the will, not mentioned in the will? Has every page been signed? You know, is it an original signature? Is it done in wet ink? And we check the will and we check it's been signed properly and it's been done properly. Because clients do weird things. You know, they add on stuff or they change it in handwritten changes before they send it back to you. And all of this causes technical problems. As Terry said, you can always go to court. Not you, your family can go to court, but that takes a year to get to court. It's a very expensive process. You've got to have counsel. The judge might say no. You don't know what the judge is going to say. So rather make sure it gets checked properly and stored
Harry,
properly.
when are you in favour of someone doing a codicil or not doing a codicil?
Look, Terry might disagree. I don't like codicils at all. I just think things go wrong. You know, the client does a codicil and he forgets what he's done in his original will and he changes stuff and he contradicts it. Just do a new will. You know, generally these wills are not, if that comes to us, these wills are free, amendments are free. If it goes to a law firm, it's not going to be hugely expensive to do a short amendment to a will. Just redo the will properly. Then there's no ambiguity, there's no contradiction, and things don't go wrong. And we've seen wills, I'm sure you have as well, where they've got like 20 different codicils and no one knows anymore, you know, what's going on, what's the original, what's changed. It becomes like a treasure hunt.
You find that, Terry?
Yes, I agree with Harry. Rather just redo a new will with a new date and re-sign it, because the codicils, as you say, it's just one error. You know, if I'm referring to 4.1 when they were referring to 6.1, and it contradicts the current will, and your wishes are then not met. So just redo, sign a new will.
And we've got Wills Week coming up in September, haven't we?
Yes, the
Yes.
favourite time of the year for us.
Yeah. Okay, let's go to some emails. Terry, to you from Raylene Belita, says, my husband passed away 5 years ago and I was appointed as executor. I engaged a professional firm at accountants, but I've seen no progress. I now wish to move to another firm. How will the fees payable to the current firm be calculated when making this change? And with the new firm, will the cost still be aligned with the statutory executor rates?
So the most important thing,
Difficult one, eh?
it's important that she's the actual executor, because that eliminates her having to have them removed. So they would just typically have the power of attorney to act in her favour. So all it comes down to is a negotiation between her and them on the fees. I think they would probably charge a time-based fee for the work that has been completed, but she would have to negotiate them down because she'll still have to go to someone else to complete the job. So I think they would charge a time-based fee, and she could ask them she could move the power of attorney away from them, but I would argue that they can't charge that much, especially if she hasn't seen any result.
Well, my next one is quite interesting. It's from Jack in Middleburg. He says, I'm the chairman of a charitable organisation. 4 years ago, we were left a house and some endowment policies by a deceased estate. To date, we have not received any funds because the deceased was married in community of property, which meant that 50% of the property belonged to the wife. She has since moved to the UK and appears to be unaware of the marriage regime, seemingly believing that she's not entitled to anything from this estate. The executors appointed a tracing agency but have no success in finding her. Would it not be possible to transfer 50% of the property to our organisation and place the remaining 50% in trust for her? If this arrangement were acceptable, then once the transfer has been completed, we would receive the bequest from the endowment policy. I'd appreciate your view. Harry?
Yeah, so I think the beauty of an endowment policy is if there's a beneficiary, and I'm assuming they've been named as
No, it said the beneficiary is the trust of the endowment policies.
So they're the trust.
No, the beneficiary of the endowment policy is left in the estate, to the estate.
Okay, so that was a mistake, obviously, because if they were the beneficiaries, then the marital regime wouldn't have mattered. They would be paid directly. Yeah, I mean, I don't see any way around that. If they want to get,
but can they do that? What I've said, can they do that? Maybe move the asset into a trust.
Yeah, I mean, I think obviously
set up, get the property out of the estate, so that they can wind up the rest of the estate.
Yeah, so I think obviously they're going to have to talk to the executors. They didn't say who the executors are there and try to come to some practical working arrangement. But that sounds very practical and very logical, that they take 50% and they leave the other 50% in trust, so there's no prejudice to the surviving spouse. I'm amazed they can't track her down in the UK. I mean, in the UK it's quite easy to track people. There actually are firms in the UK that specialise in tracking beneficiaries, so they should engage them.
Okay. Then last email, my husband was in business with a partner. He passed away, and although a policy was paid out to the partner, a major legal dispute arose, which was eventually settled in my favour. I currently hold a policy on the partner's life and have been paying the premiums. The partner now wants the policy. I believe that in addition to the premiums I've paid with interest, I'm entitled to a further benefit for ceding the policy to the partner. You know, internationally they sell policies on each other's lives, but we don't do that in South Africa.
No, because we've got English law, not American law.
Yeah.
I mean, the first thing is that if there's no agreement on that policy, this viewer can keep the policy. They don't have to cede it.
But they've got to keep paying the premium.
Right, so they must come to some arrangement. They hold the trump cards, to quote a certain president, because they've got the policy, and I'm sure that person now is probably uninsurable, which is why they want the policy. So they must come to some arrangement. But in law, they can hold the policy if they want to pay the premiums.
They can cancel the policy as well.
Cancel, and they can cash in if that person dies or is disabled. So they hold all the aces here, and they must negotiate a tough bargain.
Yeah. So, Harry, I mean, would there be any value greater than the premiums compounded with interest? Is there any extra that you'd say?
Well, the point is the viewer's the owner, and they are entitled to do what they want with the policy. So, as you say, they can threaten to cancel the policy or to not cede it. So they can create a deal that suits them. I would say premiums plus interest, depending on how old the person is. I mean, if that person that they're insuring is very old and sickly, then they can ask for more money because that policy is now a valuable asset.
Okay. Well, we've run to the end of our program. I can't even finish off other than to thank Terry for joining me this evening. Harry, good luck with your new business at Discovery. Please note our program tonight is to provide information and should not be construed as advice. Next week's program we will be dealing with, and I'm just looking at my notes, we'll be dealing with financial planning, and if you'd like to call us, my details will appear on the screen. I'd like to thank you for watching, and good night.